What is an abnormally dangerous activity? An abnormally dangerous activity is a concept in tort law that refers to activities that are inherently hazardous, even when carried out with the utmost care. In such cases, the law imposes strict liability on the person or entity engaging in the activity. This means that if harm results, the party responsible for the activity must compensate the injured party, regardless of whether they acted negligently or took every possible precaution. The roots of this doctrine go back to the famous English case, Rylands versus Fletcher in 1868. In that case, a mill owner built a reservoir on his property, but the water escaped and flooded a nearby coal mine. Even though the mill owner was not negligent, the court held him liable because he had brought onto his land something likely to cause harm if it escaped. This case laid the foundation for the principle that certain activities are so dangerous that those who engage in them must bear responsibility for resulting harm, no matter their level of care. In the United States, the doctrine evolved under the Restatement of Torts, which provides guidance on what qualifies as an abnormally dangerous activity. Courts consider several factors, such as whether the activity creates a high degree of risk of harm to others, whether the harm that may result is likely to be serious, whether the risk can be eliminated by exercising reasonable care, whether the activity is common or unusual in the community, whether the activity is appropriate to the place where it is conducted, whether the value to the community outweighs its dangerousness. Classic examples of abnormally dangerous activities include the use of explosives, storing or transporting toxic chemicals, blasting operations, and keeping wild animals. For instance, if a demolition company uses dynamite to bring down a building in a crowded urban area, it will be strictly liable for any injuries or damage that occur, even if it followed all safety regulations. Similarly, a company that transports hazardous chemicals across public highways bears strict liability if an accident releases toxins into the environment. The rationale behind imposing strict liability in these cases is that those who choose to engage in such inherently risky activities should bear the cost of any resulting harm, rather than innocent bystanders. It is a policy choice that places the burden on those who create extraordinary risks, encouraging them to internalize the costs of their activities. It is important to note that not every dangerous activity qualifies as abnormally dangerous. Driving a car, for example, carries risks but is so common and socially useful that liability for accidents is generally based on negligence, not strict liability. By contrast, activities that are unusual, pose extreme risks, and cannot be made safe even with careful conduct are the ones that fall under this doctrine. A curiosity about this doctrine is that courts sometimes disagree about what counts as abnormally dangerous. For example, crop dusting with pesticides has been treated as abnormally dangerous in some jurisdictions but not in others. Similarly, storing large quantities of flammable fuel might be considered abnormally dangerous in a residential neighborhood, but not in an industrial zone where such storage is routine. The classification, therefore, depends heavily on context. Another interesting point is the interaction between abnormally dangerous activities and modern environmental law. Many environmental hazards, such as toxic waste disposal, fall within this category, making strict liability a powerful tool for holding companies accountable for ecological damage. In conclusion, an abnormally dangerous activity is one that carries such extraordinary risks that the law imposes strict liability on those who engage in it. Its historical roots in Rylands versus Fletcher, its modern applications in explosives, chemicals, and environmental hazards, and its focus on fairness to victims all make it a cornerstone of tort law. By shifting responsibility to those who create unusual dangers, the doctrine ensures that the costs of hazardous activities are borne by those who benefit from them, not by innocent third parties. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.